Hi, my name is Morgan Leigh. I'm with Scrofano Law PC, and I'm here to talk to you today about extreme risk protective orders in the state of Maryland. Our firm gets a lot of calls from individuals, both who want to know how to get a protective order against someone, as well as individuals who have been served with an extreme risk protective order. So today we're going to give you a little bit of background information on what an extreme risk protective order entails. So first, what is an extreme risk protective order? An extreme risk protective order, also known as an ERPO, is a civil order issued by a judge ordering an individual to surrender firearms and ammunition, as well as ordering them not to purchase or possess firearms or ammunition during the duration of an order. The court may also refer someone for an emergency mental health evaluation if the facts support such a finding. An extreme risk protective order can last up to 1 year and be extended for 6-month increments for good cause. So who can file for an extreme risk protective order? A spouse, a cohabitant, a relative, a person with a child in common, a current dating or intimate partner, a current or formal legal guardian, a law enforcement officer, as well as a medical professional who has examined the respondent. So who could be the subject of an extreme risk protective order? In other words, who can an extreme risk protective order be filed against? A person who poses an immediate threat and present danger of causing injury to themselves or others by having firearms. So there are some factors for the court to consider: alarming behavior and statements, unlawful firearm possession, reckless or negligent use of firearms, violence or threats of violence, violating peace or protective orders, drug or alcohol abuse, information and health records, such as the presence of a mental health disorder or an acute risk of suicide. That's a very common one. What can an ERPO, or an extreme risk protective order, not do? It can't order someone not to contact you, threaten you, harass you, vacate a residence. That's a different form of protective orders, and we do handle those as well. Now, how does one apply for a protective order? Well, you file a petition with the relevant facts in the district court or with the commissioner if the district court is closed in the county where the conduct occurred or where the respondent resides. You need to list specific facts with the behavior that forms the basis of the protective order. For example, the individual leaves firearms around the house and there's minors in the home. This individual is addicted to substances and drugs or has a mental health issue. Now, the petitioner cannot be held liable if they file the protective order in good faith. The initial proceeding is held ex parte, meaning it's just you, your attorney, and the judge. If the judge grants the temporary order, which is the order that they grant that's ex parte, then a final hearing will be scheduled where both parties can present evidence. Now, if you've been served with a protective order, you have to immediately surrender firearms to the local law enforcement agency. You should contact an attorney immediately because these proceedings move very fast, and an attorney needs time to prepare. An attorney can explain the process and explain what you can do to minimize the risk that a final order will be issued against you. They can help you present evidence and object to evidence. They can help you get involved in mental health or substance abuse treatment that would satisfy the court. They can facilitate communication with sheriffs and law enforcement regarding the surrender of firearms. Then there are some collateral consequences to consider. It can interrupt employment that requires the use or possession of firearms. You could have your TSA pre-check or global entry revoked, and you could have to complete substance abuse and psychiatric treatment. An attorney can also help you modify or rescind a protective order. If there is a good basis to ask a court to terminate the protective order, that's what we mean by rescind, and an attorney can help you with that. Now, you can get your firearms back as long as the respondent is not otherwise prohibited from possessing the firearm. They should be returned no later than 14 days after the expiration of an interim or temporary ERPO, or 14 days after a court terminates an ERPO or 48 hours after the expiration of an ERPO in the ordinary course. A lot of questions, we also get a lot of questions regarding records of extreme risk protective orders. These are confidential proceedings that are not open to the public. However, court personnel, the Maryland Department of Health, and law enforcement do have access to these records, as well as the respondent and counsel for respondent. I hope you found this video useful. If you are interested in obtaining an extreme risk protective order against someone, or you have been served with a temporary extreme risk protective order, give our office a call and we can give you a consultation to explain to you what the rights and responsibilities are related to extreme risk protective orders. Thank you.